episode of On the Record. I am your Marion County Recorder, Faith Kimbrough.
And I'm your Chief Deputy Recorder, J.R. Ryder.
And today's show, let me just tell you all, you're going to need a pen and some paper. It's going to be so informative, and we'll be right back.
Welcome back to On the Record. Our guest today is Lori Hemp. She is actually the founder and attorney of Momentum Title. Welcome to our show.
Thank you so much. I'm thrilled to be here today.
We're really glad to have you. So let's talk about property fraud for a moment.
But wait. I got to break it in. Before we talk about property fraud, I just want the viewers at home to know that the Recorder's Office holds public records of property transactions such as liens, deeds, mortgages, and more. Come on.
Liens, deeds, mortgages, and more.
So, Lori, at the end of the show, you're going to be tested to see if you can do the jingle.
All right.
Okay? All right.
You ready for the quiz?
I'm ready.
All right. Well, let's start off with property fraud.
Okay.
Right now, it's all across America. It's has interjected in every county in America, and we see it everywhere now. So property fraud, we have a tool that we use. It's called Property Fraud Alert, which helps citizens to get ahead of it. It doesn't really prevent it, but they can at least get a notification if something happens with their deed. So how can we work together from the title side to actually prevent fraudulent deeds from going forth?
Sure. It's something that we worry about every single day in our business. And actually, we've been working with the counties. So we have been, up until recently, primarily in the southern part of the state. So Clark, Floyd, Harrison, Washington, Scott counties, Jefferson County, throughout southern Indiana. We recently have an acquisition. So now we're from about Greenwood up to Lafayette. So now we're covering those counties. But we have started partnering with our counties and asking them to give us the cards, the information. So each time we're doing a transaction, we're providing to both the buyers and the sellers, and we're giving them that information and encouraging them to register. Like you said, it doesn't prevent it, but they can at least get that notice right away.
Yes.
Beyond that, my husband and I, who started this company, are huge on education. So we have really started partnering with the lenders, with the real estate agents to do education, to alert them to the different fraud scams that are out there. We're seeing it both on the buyer and the seller side. So I know that e-signing is great and convenient. I hate it. Being in title, I hate it. I like in-person closings. I want people to come to the table. I want them to bring me 2 forms of identification that I can verify that it's them. So when I'm notarizing a document, I'm seeing them. They're in the room with us.
Right.
We require now, when it's a mail away, when someone can't physically be there, if we can't have a notary that we've selected go and meet them, we use a third-party company certified that will verify who those people are and actually provides another layer of indemnification. So they'll have to complete some information online, upload IDs, take a live picture of themselves where they then verify and match it. So we're trying to add those steps. I do feel like our industry is so targeted for fraud.
Sure.
Everyone has to be alert. I would recommend to people, especially if they're going through a process of potentially buying a property, selling a property, or going through a refinance, to be extremely vigilant with their emails. The spoofing scams, they're so much better than they used to be. These emails that come in look legitimate. Before you click on a link, before you open an attachment, make sure you know where it's really coming from, and that's it. Scroll that roller over. Call and check with the person that's sending it to you, because I think oftentimes that's where we're seeing these initial problems come through. The emails are getting hacked. They know when closings are happening or when properties are going to be transferred, and they're trying to get in there. And then they will send something that looks like it's from a title company or gain additional information. For better or worse, our county records are public records.
Correct.
They are.
People get access,
Mhm.
can get access
Mhm.
to those and get a fair amount of information. So
And that's where our hands are tied
yeah.
because we can only do so much from the
Right.
recorder's office.
Mhm.
Yeah, so I think it's all of us trying to educate as much as we can the public, encouraging them to take advantage of the tools that the county offers, and then I think those are the highest at risk that are going through the transaction, and us trying to educate their partners. And we send out information. We try to do as much training as we can, but having them be alert for those potential scams, clicking on the wrong link. And then again, we're doing on our part, making sure that the parties are there that are signing the deeds, that are transferring the property, are truly who they say they are.
Absolutely.
I like the third party piece. So I
Mhm.
think we may even look at maybe suggesting that or having someone to adopt that. So let's move on. Thank you so much. Let's move on to this question now. I have to put on my glasses here. You know, we're over 50. That's okay. And I have my card because this is a lengthy question here.
Okay.
So the question is, should a transfer on death deed, which we call it the TOD in the office, be recorded at the time of execution of the deed or wait until the grantor has died?
Mhm.
Example, Mary completed a TOD at her attorney's office in December 2023. The daughter, the grantee, was to be the recipient of the property. The daughter brings the deed to the recorder's office on March 24th, 2025, to record after Mary's death on March the 13th, 2025, with a copy of Mary's death certificate. So again, should a transfer on the deed, the TOD, be recorded at the time of the execution of the deed or wait until Mary has died?
Yeah. The short answer is it needs to be recorded before the death. But let me just talk. Transfer on death deeds are a very useful tool, and not every state allows them. Indiana does.
Yes.
It's a very useful tool for someone that wants to make sure their real estate property gets to a specific person without them having to go through probate and spend the time and the expense to get it transferred. But we all know if you add someone onto a deed while you're alive, they've got an immediate interest. So you may not always want to do that. So that transfer on death deed lets that person say, I own this property throughout my life. As soon as I die, I want it to go to this person. But by statute, it has to be recorded before the death. The good news is people can rest assured that even if they record it, if something happens and they later decide they don't want that person to be the beneficiary, you can always revoke that. You can always do a new one. So there's no reason to hang on to it. But absolutely, when you look at the statute for transfer on death deeds, if they are not recorded prior to the death, technically it's not valid. So if that transfer on death deed is recorded and it hasn't been revoked, there hasn't been something subsequent recorded, as soon as that person dies, that property legally becomes the beneficiary's property. Now there is an added step that they do take, then they should come down after with that death certificate and they can file that affidavit just so everything is cleaned up within the record and we make sure tax bills are going to the right place. We want the auditor, the assessor, everybody to get that information. But yeah, so I do think sometimes a little bit of knowledge is dangerous. So I think our friend Dr. Google might tell people about transfer on death deeds and they might think they're getting a really good tool, but if they don't take that added step, they're not completing it. So a great resource for people to have, but you gotta make sure everything's done the way it should be.
Great, thank you.
Great answer. I have a similar question regarding power of attorneys.
Yeah.
So let's say we have a property owner. They get a power of attorney, a POA. So how much or what are the ramifications if that owner decided to transfer or add someone to their deed after they've already added a POA?
Again, powers of attorney are great tools, and we encourage people. It's actually one of the things. We've got multiple attorneys on staff, so we'll provide some basic services to some of our clients. We think everybody should have a basic will and should have an executed power of attorney because we never know what's going to happen. But there are different types of powers of attorney. So there are powers of attorney that are only triggered if the grantor, the person that holds it, becomes incompetent or unable to act, it would be triggered only then. So up until that time, if I'm alive, well, coherent, even though I signed a power of attorney, that person that I gave the power of attorney to, that attorney in fact would have no authority and couldn't do anything.
Oh.
Then you have ones that take effect immediately and allow the person to act. But the person that the person that was giving that right, if they're competent, they still hold the ultimate authority. Yeah, so they have the authority. Now, we can get into some difficult times, perhaps as people are aging, or they might suffer from dementia or an illness, and perhaps you have a child that's disagreeing. We'll have situations where someone will come with a power of attorney. Again, we're always very vigilant about fraud, especially when we think about elder abuse. So we will try to, you will have a conversation with them and say, you know, is your mother, or is this person available that we can speak with? And if it's just simply a fact that they're ill and unable to come to closing, it's too taxing, we'll ask if we can speak to them by phone. I've even traveled to nursing homes or assisted living to meet with them just to ensure that they understand what's happening, and even to ask them, how do you want the proceeds to be handled? Do you want it in a check payable just in your name, or which account do you want it in? Making sure that they are aware of what's happening. If we know that they are incompetent, perhaps unable to grasp, we don't want to put anyone through more stress if it's their personal home being sold and they don't understand or grasp it. We don't want to do that, but we've called healthcare facilities, or like I said, assisted living, and we've spoken with directors and said, we're doing a real estate transaction. We have a power of attorney that's held by this person. Is this someone that you have on record as being a caregiver or provider? Just to try to add that layer of protection. So again, powers of attorney are wonderful to have. If you don't have one and something catastrophic happens, you end up having to go to court and file for a guardianship. So it's can be time consuming and costly. So it's good to have, but a person can rest assured, if they've done it, they can limit or contain what that can be used. And again, they're not giving up their power to have the ultimate decision. So if we were to have a conflict between someone that had a power of attorney and someone that had given it, we would follow by the person that had given it unless we had some medical documentation or something that showed us that they couldn't make those decisions.
Good to know. And that's the whole reason why we advise our constituents to seek legal counsel whenever we get questions in the office like that. So
again, Dr. Google is great. Lots of forms that are online. You can go to your local library and get information, those things, but they're not attorneys. They can't and shouldn't be giving legal advice, even with AI. It's only so reliable. And I think I'm an attorney, my husband's an attorney, there are lots of good attorneys out there that will not charge a fortune for doing those basic things. And this is a big investment for people. And if you can accomplish that for a few $100s, it's much better to make sure it's done and done properly. We've had powers of attorney people come in and say, we downloaded this, got mom to sign it. It's not properly notarized, or it doesn't include the language that's needed to sell property. And so they've got it, but now mom's unable to execute a new one, and we have to tell them this isn't valid. I'm sorry, we can't rely on this because we can't record this. It's not properly notarized or witnessed, and we know we can't utilize it for a real property transfer. So that's where that added step of, like I said, not all attorneys are bad.
Well, this has just been very educational, even for myself. So I hope the viewers at home have wrote down some things, some information. Please share it. But before we go,
quiz time.
I've talked a lot.
my office again hosts public records.
Yes, you do.
Of property transactions, such as
deeds, mortgages, liens.
Come on. Liens, deeds, mortgages, and more.
There we go. I got them all. Just the wrong order.
Thank you, Laura.
Thank you. It's been a pleasure.
Well, JR, I think that was a really, really great show.
Very, very informative. I think that's probably one of the best shows we've had yet so far.
I think so too. Lori, she just explained the power of attorney, transfer on debt, and definitely the fraud.
And hopefully that will trigger people to want to go seek legal counsel for
Absolutely.
any kind of situations like this.
Yes. Well, thank you all for joining, and we'll see you next time.